Good afternoon. Thanks everybody for being here. We're going to go ahead and get started. I'd like to welcome Dean Anaya to come on up and say some welcome remarks. This is Dean Anaya's first Rothgerber Moot Court competition, which is the premier moot court competition, internal competition for the law school, and has a long tradition. And we welcome Dean Anaya to this event and this afternoon, and we welcome all of you.
Okay, is this working here? I don't know if I put this on correctly. I always tell people when I start one of these that I'm a 1L, just like our first year. So because this is my first year here, but it's my pleasure to welcome you to this event. And in 1951, Ira Rothgerber Jr. established this annual appellate court competition at Colorado Law School in honor of his father, Colorado Law graduate Ira Rothgerber Sr. You can see more on Judge Rothgerber's background in your programs. For more than 6 decades, this has been the premier moot court competition at the law school, providing our students an opportunity to build on and showcase their advocacy skills. In keeping with the full tradition of the competition, students this year competed on opening rounds with briefing of the problem and participated in multiple preliminary rounds of oral argument. Today's finalists are clearly outstanding representatives of the second and third year classes here at Colorado Law. We congratulate this year's top 4 finalists, Ryan Lorch, Chip Hennessy, Timbre Shriver, and Josiah Beamish. And we wish each of you luck in today's oral arguments, and that's all for the applause. Till the end, let's say, okay? Part of the rich tradition of this competition is also the distinguished panel of judges that we are able to welcome each year for the competition. And you'll see them before you in just a moment. And they are Justice Márquez of the Colorado Supreme Court, Judge Paul Kelly from the 10th Circuit Court of Appeals, and Judge David Barron, who weathered the storm from Boston. He's on the First Circuit's Court of Appeals to make it here to Colorado. We look forward to watching the spirited questions from the bench today. And hopefully we will get an opportunity to thank each of the judges for being here at the reception following the argument. And the reception will take place in the Rothgerber Reading Room in the library. I would also like to take this opportunity to thank the law firm of Wheeler Trigg O'Donnell for their sponsorship of the various events that are surrounding the competition. And I thank Eric Robertson, who is here representing the firm. Eric, there are you. There, thank you. You can welcome Eric. And finally, I would like to recognize all former Rothgerber competition alumni who are with us for today's competition. Could you raise your hand or stand? The former, there you go. Let's give them a round of applause. Thank you. Thank you. And it really is an honor each year to welcome back the outstanding advocates who have participated in the competition. And finally, I'd like to thank you all for being here, and I'm sure we're all in for a real treat, and good luck to you.
All rise. The United States Supreme Court is now in session. Justices Kelly, Barron, and Chief Justice Márquez presiding.
You may be seated. Good afternoon. and welcome both to council and to all the audience members today for this round. I'm going to call the case. We have case number 39-005, Winston Smith versus the United States of America. Would council please enter their appearances?
Good afternoon, Your Honor. My name is Ryan Lorch, L-O-R-C-H, and I represent the petitioner, Mr. Winston Smith, and I will be arguing the first issue.
Thank you, Mr. Lorch.
Good afternoon, Stephen Hennessy for the petitioner, issue 2.
Thank you.
Good afternoon, Timbre Shriver for the respondent, issue 1.
Thank you.
Good afternoon, Josiah Beamish for the government respondent, issue 2.
Thank you. And petitioners, do you wish to reserve time for rebuttal?
Yes, Your Honor. We would each like to reserve 2 minutes of time for rebuttal.
Thank you. Okay, Mr. Lorch, you may proceed.
Madam Chief Justice, and may it please the Court. I am Ryan Lorch, and along with my co-counsel, Mr. Stephen Hennessy, we represent the petitioner in this matter, Mr. Winston Smith. The petitioner requests that this Court vacate Mr. Smith's conviction and reverse the 12th Circuit's decision. Your Honors, we're here to determine what level of privacy society is reasonably willing to accept. In today's technological era, people are not willing to accept the government tracking their every movements, every day, at every hour, simply because they own and carry a cell phone.
Well, they own and carry a cell phone that gives away their location wherever they are. Isn't that correct? And they know that when they buy the cell phone.
Your Honors, in this case, there's no facts in the record which indicate whether or not Mr. Smith knew that Apple automatically installed such triangulation service on his phone.
Whose problem is that?
Your Honors, in this case, it's society's problem. It's everyone's problem.
Well, it might be, but it might also be your problem, because don't you have the burden?
Your Honors, we here today have to show that the government's actions constitutes a search under the Fourth Amendment, which will be my main first point. Second, my co-counsel will come up and argue that because a search occurred under the Fourth Amendment, under an expired warrant.
But if the record's silent on whether your client knew or didn't know whether the cell phone was disclosing that location, why isn't it incumbent on you to put in evidence in the record that suggests he didn't know?
Your Honors, the record is devoid of any type of fact that shows such information.
Well, don't we assume then that when your person bought the cell phone, he knew what it would do, and he knew that he could turn it off if he wanted to?
Your Honors, in this case, the memory hole triangulation application service was automatically installed by Apple after Mr. Smith had already owned the phone. So in this case, we contend that there's nothing in the record that specifically indicates that
No, it
Mr.
was
Smith...
installed before he bought the phone.
Your Honor, memory hole automatically installed the memory hole application service on every iPhone
Right.
around the country.
So he had it when he bought the phone. It had that facility.
Your Honors, it's the petitioner's contention in this case that Mr. Smith already had the iPhone and that memory hole Apple automatically installed the memory hole triangulation service on his iPhone. Your Honors, I'd like to begin our discussion of the Fourth Amendment and analyzing which type of standards this court should use in analyzing whether or not a Fourth Amendment search had occurred. Now, prior to this court's decision in United States v. Katz, courts applied a strict trespassery test that looked at the nature of the intrusiveness of the government's actions. And one of the main factors of that test was whether or not a physical intrusion had occurred.
Well, that was Jones also, wasn't it? The majority opinion?
Jones did apply a sort of trespassery test, correct, Your Honor. However, Justice Alito and Justice Sotomayor, in their concurrences in United States v. Jones, were very particular in noting that the reasonable expectation of privacy test, which the petitioner will today contend is the proper test for analyzing these types of searches, should have been the test that Justice Scalia used in his.
Well, he didn't, though.
Yes, that's correct, Your Honor. However, the reasonable expectation of privacy test is flexible enough to allow for courts such as this one to analyze specific, long, intrusive searches such as this.
But here, there was no long, intrusive search by the government. There was only a gathering of records that just happened to exist in the world by a third party. So we don't have a case like Jones where the government has tracked your client. We just have a case where the client was tracked through actions that had nothing to do with the government, and then the product of that tracking sits somewhere in a company's files, and the government is now getting those files from that company. So given that, why is Jones in that set of cases relevant?
Your Honors, Jones and the other types of cases that deal with this type of tracking, long, intrusive searches, such as State v. Earls out of the New Jersey Supreme Court, the Garfus opinion that dealt with an 113-day search out of the Eastern District of New York.
But are those cases also where the government did the tracking?
No, Your Honors. Those are searches where the government either applied for an application to obtain such stored communications information.
And we've never had a case in which we've said that stored communications are potentially something that you have a privacy interest in when they reside as documents owned by a third party.
Yes, Your Honor, and that's exactly why this court needs to take the opportunity today to state that an individual still has an expectation of privacy in his daily movements and when he's in constitutionally protected places.
Well, he might. And if the government were directly tracking him, that expectation of privacy might matter. What I'm curious is, why should we translate that to a situation in which the tracking was not done by the government, and now there are records in a company's files, just like in Miller, and the government is just asking that company, it's not breaking into the company's offices, it's either getting them consensually or it's getting them through whatever means it does. But why is it a concern of somebody who doesn't own the records?
Your Honors, I think there's a couple reasons why this type of search can be as of, if not more intrusive than the government instigating such tracking. Specifically, this type of search allows the government to retrospectively go back, in this case, through 6 months and 9,000 pages of Mr. Smith's locational information. Now, if this court were to find that—
But I'm still, if the company handed these documents over to the government, it would be just as intrusive, but you would agree there's no Fourth Amendment problem.
we would not agree in this specific
If the
case.
government, if the company just handed them, they just sent a package to the government, here's 9,000 files of Mr. Smith, the government would be barred from looking at them and using them?
Maybe not directly in those facts, Your
So
Honors. However,
that's because
in this
the
case—
records are in the possession of a third party.
But in this case, Your Honor, there's nothing in the record that indicates that Mr. Smith knew that his information was being collected by a third party and stored in these types of servers. There's 184 million smartphone users in this country.
But that would also be true if he didn't know about it and the company had all those records and sent it in a package to the government. He wouldn't have known it. All that information would exist. The government could clearly use it without there being a Fourth Amendment limitation on the government using it.
But in this case, Your Honor, the government was the one that instigated this by going to Airstrip 1 and told them to collect such information, and Airstrip 1 complied.
Well, they had it already collected. They just had a matter of giving it over, wasn't it? In
Yep.
response to the warrant?
Yes, Your Honor. However, such a narrow application of the third-party doctrine exposes
Well,
millions—
it's not really a third-party doctrine. I mean, my colleague here, I think, is talking about the reasonable expectation of privacy in the existence of that information. I don't think that's necessarily a third-party doctrine argument.
Well, Your Honors, the petitioner contends that there is a third-party doctrine issue here. And the issue arises because Airstrip 1 is the third party that collected this information and complied with the government. Now, the two Supreme Court cases in Smith v. Maryland and United States v. Miller set a narrow line that when a defendant voluntarily and knowingly conveys his information to a third party, that his Fourth Amendment rights are extinguished in those cases. It's the petitioner's contention today that the petitioner did not either voluntarily nor knowingly convey his information. Thus, the third-party doctrine is inapplicable in these narrow situations, which is exactly what we have here.
And why does what I'm trying to figure out, why does that matter, whether he voluntarily disclosed it to the private entity or not? Because whether he knew what he was doing or not, if the private entity collects those records and gives it to the government, you have to agree that your client has no Fourth Amendment right to stop the government from using it. So why does it matter whether he did it voluntarily or not? The fact of the matter is there's information in the hands of this company created for that company's purposes. And that company doesn't seem to have a problem with the government looking at its records.
Your Honor, the company might not have a problem with the government looking at the records, but Mr. Smith certainly does, and society certainly does. Allowing the government, without a warrant, to gather thousands of pages of information of someone's specific and private locational information impinges upon Mr. Smith's expectation of privacy in his daily movements and also within constitutionally protected places.
Well, counsel, there was a warrant, though, wasn't there?
There was a warrant, Your Honor, for 7 days.
Well, is that jurisdictional, or is that constitutionally required?
Your Honor, there's nothing in the record that says that it was jurisdictional, but there was a 7-day warrant that was issued by the magistrate. But
There was a finding of probable cause, though, by the magistrate, a neutral magistrate, and he issued the warrant, correct?
Correct. And as my co-counsel, Mr. Hennessy, will come up and argue that the magistrate found probable cause for 7 days, and the government executed this search after the warrant had expired.
Well, but do you think that the expiration of the warrant or the expiration of the time in the warrant voids the warrant?
Your Honors, it's petitioner's contention is Mr. Hennessy will argue that the ability for the government to execute this warrant after it expired leads to suppression under the exclusionary rule.
Can I ask you a hypothetical? Suppose your friend breaks into your house, steals your diary. Okay, now the government understands that your friend has your diary, and they have probable cause to seek it. Okay, and they do a warrant. Let's imagine it's got a little bit of a issue with it, as here. Does your client have an interest, a Fourth Amendment interest, in stopping the government from getting the diary now that it's in the possession of a different party and the government had nothing to do with how it got there?
Your Honors, I think in those limited fact patterns that the individual may have a lesser expectation of privacy in those specific documents. However, the New Jersey Supreme Court in State v. Earls dealt with a very similar situation.
Because the rule you're asking to adopt, the problem with it is the government has to then figure out, whenever it seeks information from party A, how A got it. And why should the government be put to trying to figure out every time how did A get it? All they know is X has that information, and as long as they have probable cause to get it or that party doesn't mind them taking it, what reason is there, what Fourth Amendment interest is served by requiring the government to figure out how the information got to the party that it's seeking it from?
Justice Barron, this ties me very well into the second point of the reasonable expectation of privacy test, which is whether or not society is willing to accept Mr. Smith's expectation of privacy as reasonable. Information today is being conveyed to third parties at all times. I'm carrying a cell phone right now. Your Honors, you may be carrying a cell phone with you right now as well. Society is willing to accept the intrusiveness of cell phones.
Your cell phone is turned off, isn't it, counsel?
It's in my bag, Judge Kelly, so it won't go off.
But it may still be telling us where you are.
Yeah. And that's exactly why this court needs to set a precedent, that individuals have an expectation of privacy in their daily movements in constitutionally protected places in cell site location information that's unknowingly conveyed to a third party.
There's just an irony, because you keep saying how society is so outraged by this, but you would think if society was so outraged, there might be a legislation that would prevent this kind of disclosure from occurring, and yet there isn't.
Well, Congress has come close, and the Wireless Communications Act.
As you know, the saying goes.
Yes. However, Your Honor, the legislative history in the Stored Communications Act and the Wireless Communications Act indicated, I see my time is up. Would you like me to finish my response?
Please go ahead and answer the question.
That the legislative history indicated that representatives are weary of such type of cell site locational information. Therefore, we ask this court to reverse the 12th Circuit's decision and find that a Fourth Amendment search occurred. Thank you, Your Honors.
Thank you. Mr. Hennessy. Please proceed.
May it please the court. My name is Stephen Hennessy, and I represent the petitioner, Mr. Winston Smith. Because the government conducted an unlawful search, we respectfully ask that the court invoke the exclusionary rule. First, the execution of a facially invalid search warrant is subject to suppression.
Well, why is it facially invalid when it was issued by a neutral magistrate and it was just a matter of 2 days past the limit in the warrant?
Because, Your Honor, pursuant to this court's reasoning in Sigro v. United States, the magistrate determined that probable cause existed for 7 days.
But you don't think it existed for 2 more days?
No, Your Honor, there's no facts in the record to support that conclusion. The government executed the warrant after 9 days and therefore violated the judicial mandate.
Well, you're familiar with United States versus Sims, aren't you, out of the 10th Circuit?
I am, Your Honor.
And didn't they just sort of blow right by that 1 day expiration?
Yes, Your Honor. In United States v. Sims, the 10th Circuit held that where officers executed a warrant 1 day late, that search was valid and therefore not subject to the exclusionary rule. However, when you apply the 10th Circuit's framework to the facts of this case, that reasoning does not apply. In Sims, the court held that first, it was a non-prejudicial violation of Rule 41.
Well, what's the difference between that and this?
Your Honor, here, the government executed the search 2 days late. There are no facts in the record to support the court's conclusion in Sims. In Sims, the court reasoned that it was a non-intentional violation because there was evidence to support that conclusion. Furthermore, the court reasoned that there was no effect on probable cause. Again, without facts to support such a conclusion, the court cannot reason that this had no effect on probable cause.
There's something about the nature of the information that would be supporting probable cause for this warrant to think that it was somehow time sensitive. I mean, this isn't sort of we're worried that the cocaine stash is going to get moved from location A to location B. These are records that are sitting for 6 months on a rolling basis at AO, so.
Your Honor, we don't contest the magistrate's initial finding of probable cause. We realize that there are arguments there, such as relying on an anonymous tip. However, that would likely fall under some form of good faith exception.
But you're saying that the probable cause, the basis for probable cause somehow evaporated at the end of the 7th day or 9th day, sorry.
Your Honor, in Sigro, this court held that probable cause is only valid for the life of the warrant, and that when the government violated that judicial mandate, the probable cause did disappear.
Well, let's say Sigro said something that doesn't make a whole lot of sense. What are we supposed to do about that? I mean, in other words, what reason is there to think that the probable cause determination in this case turns on whether it's 7 days or 9 days?
Your Honors, without a copy of the search warrant or facts supporting the magistrate's finding, we cannot challenge that conclusion. What we can challenge is that that the government executed the search 2 days late. Therefore, that search should be subject to the exclusionary rule. Now, we acknowledge that there are additional exceptions.
And if we don't know whether they did it inadvertently or maliciously, because the record's silent on that point, what are we supposed to assume? Why do we assume the government must have been doing it intentionally rather than inadvertently?
Well, Your Honor, in Ramirez-Rivera, a First Circuit decision, the court reasoned that the government bears the heavy burden of proving that the good faith exception applies. This is the good faith exception, not the bad faith qualifier. I cannot prove to you based on...
I think aren't we on a different angle here? I thought we were trying to figure out whether the exclusionary rule applied as opposed to whether there's a good faith exception. The argument here isn't that there's something about an appellate court opinion that decides the case, or that there's a statute that gave them the right to do it, or that the warrant on its face, though wrongly issued, said they could do it. This is assume a violation. What reason is there to think it's the kind of violation that we should suppress the evidence for? And why don't you bear the burden on that?
Well, Your Honors, the government cited United States v. Bedford, a Third Circuit decision, in its brief. In that case, the search warrant mandated that the search be executed forthwith. However, the officers executed the search warrant 8 days later. The court reasoned that because forthwith was rather vague, that this was not a direct violation of the warrant. However, in this case, the magistrate provided an explicit mandate to execute the warrant in 7 days. 7 does not equal 9. The government violated the face of the search warrant, a valid judicial determination of probable cause. We encourage this court to adhere to the dissent's reasoning in United States v. Bedford. Judge Rosen reads it, and I quote, "A search conducted after the expiration of probable cause is no more lawful than one for which probable cause never existed. Transgression of a judicially determined time limit for execution of a warrant is as much a violation of the Fourth Amendment as a warrantless search." Here, the government blatantly ignored the magistrate's mandate. Therefore, the search should be subject to the exclusionary rule.
Was this raised below,
What was raised below?
that the warrant was void because of the two-day differential?
Yes, Your Honor. On appeal, the government likely contended that this was, in fact, a driving issue behind the invocation of the exclusionary
Was it
rule.
raised, though, in the district court?
We don't have a record of what the district court reasoned.
All right.
The government moved to suppress this evidence. Now, Your Honors, in this case, the good faith exception does not apply. The governing case for the good faith exception is United States v. Leon. In that case, police relied on an anonymous tip and good faith observations. It ultimately executed a facially valid warrant that was later found to lack probable cause. That search was upheld because the officers acted in good faith.
What evidence is there that they didn't act in good faith here?
Well, Your Honor, as I mentioned earlier, United States v. Ramirez states that the government bears the heavy burden of proving that the good faith exception applies. Without any evidence of good faith, the court should always err on the side of the Constitution. It's ultimately the government's burden to prove that the officers either engaged in some administrative oversight or overlooked the expiration date. An example of that would be in Herring v. United States. In that case, the police executed a recalled warrant after the county failed to update its database. Ultimately, the officers thought they were executing a valid warrant, but because of an administrative oversight, that warrant was invalid. Here, there's no evidence that the county failed to update its database or that there was some sort of oversight. Rather, the police executed a warrant that was facially invalid. It was expired, and therefore, they completely ignored the judicial mandate to execute a search within 7 days.
What's just a little puzzling is I'm trying to figure out for whose benefit this 7-day limit was imposed. Because as the case comes to the judge issuing or magistrate issuing the search warrant, the party that he's focused on most likely is AO. And the timeliness and promptitude of doing the search for the interest of AO. But AO doesn't seem to have any problem with the fact that it was late. The only person that's got a problem with it is somebody who wasn't necessarily front and center as the object of the search. So how does that affect things?
Your Honor, this case is not just about AO or Mr. Smith. This case is about setting forth judicial precedent.
No. What I'm asking is, for purposes of, you want us to have a very strict rule that if there is a violation of the time limit, even though nothing on the face of the record suggests it was done intentionally, and even though nothing on the face of the record indicates that the probable cause determination that the magistrate made would dissipate if it was done late, and even though the time limit in all likelihood was set with the interest of AO in mind rather than your client should benefit from the exclusion. I'm trying to figure out why that would be.
Because it's necessary to set forth judicial precedent that will deter future Fourth Amendment violations in the future and safeguard the judiciary's check on the executive. As I mentioned, this case is about more than the parties. It's about setting forth governing precedent.
But the deterrent component there is to deter bad behavior by the police. So where's the bad behavior if we don't have evidence of bad faith conduct here?
Your Honor, it's beyond bad behavior. It's about ensuring respect for the judiciary. In Wong Sun of the United States, this court reasoned that the Constitution requires that the deliberate, impartial judgment of a judicial officer be interposed between the citizen and the police. Here we had a magistrate that did interpose between the citizen and the police, but that magistrate determined that probable cause existed for 7 days. The government ultimately violated that determination.
Is that what he determined? I mean, do we know that's what he determined, or do we only know that there was a 7-day time limit for executing the warrant?
Based on the record, we only know that there was a 7-day time limit, and we can assume that there was probable cause.
But we could assume we can assume that there was probable cause, but why would we assume that the magistrate thought probable cause existed only for 7 days? There may be all kinds of administrability reasons why the magistrate chose to impose a 7-day time limit. We don't know that that was because the magistrate thought probable cause only would last for 7 days.
Your Honor, the rule that we're proposing to this court is that where the government executes a search warrant after that warrant had expired, the evidence must be suppressed unless there is evidence of good faith. Here there is no evidence of good faith, and this type of decision is absolutely imperative in the context of the modern technological era.
Well, you raising this to a constitutional level?
Yes, Your Honor.
And what is your authority for that?
Under the Fourth Amendment of the United States
Well,
Constitution.
what cases do you have that support raising the time limit to a constitutional level as opposed to simply a judicial imposition?
I misspoke, Your Honor. The exclusionary rule is a form of judicial rule that ensures that the executive complies with judicial mandates. In Federalist Number 78, Alexander Hamilton reasoned that the judiciary is the least dangerous branch of government. Unlike the executive, it wields no sword. Unlike the legislature, it wields no purse. When a decision must be made as to whether the government should infringe on an individual's privacy, that decision should always be left to the least dangerous branch, a branch whose power is premised on reason. Here we had a magistrate judge who reached a determination that the government could search the private location information for a defendant for 7 days. The government violated that judicial mandate. Therefore, the court should find that this evidence should be suppressed because the executive ignored the judiciary's mandate here. Your Honors, if there are no pending questions, I reserve my time.
You may. You may proceed.
Madam Chief Justice, may it please the court. My name is Timbre Shriver, and I, along with co-counsel Josiah Beamish, are representing Respondent, the United States of America. We respectfully request that you uphold the decision of the 12th Circuit. I argue that police collection of cellular triangulation data did not constitute a search under the Fourth Amendment, and Mr. Beamish will argue that even if it had constituted a search, the exclusionary rule does not apply in this instance. However, the court need not get to the analysis of the exclusionary rule today because police officers' collection was not a search for two major reasons. First, Mr. Smith did not have a reasonable expectation of privacy in his cellular data.
Was there anything in the record to support that?
Excuse me, Your Honor?
Is there anything in the record to support that statement?
That Mr. Smith did not have a reasonable expectation of privacy? Mr. Smith's actions Mr. Smith's actions did not convey that he had an expectation of privacy. He was wandering around a public thoroughfare where he readily could have been discerned by any number of his acquaintances, and in fact was convicted by a jury of robbing a public building.
So just so I get the government's argument, if they secretly had a tracking system of him that they instituted on their own, they don't need to get a judge to approve that. They had some secret device that could follow him around everywhere he went, every little movement he made. That'd be fine.
Your Honor, those facts are similar to this court's decision in United States versus Knotts, where the police installed a beeper monitor in a container that was then conveyed to the defendant. In that instance, the court found that the police officers could track the defendant along public highways and even to the point where he arrived at the home.
But didn't that turn on the fact that the beeper was in the can before the individual purchased it or acquired it?
Absolutely, Your Honor.
And in this case, your colleague indicated that this app, if it will, was automatically put on his cell phone after he already owned it. Is that correct? Do I understand that correctly?
Your Honor, the application was installed prior to the petitioner's receiving of this device.
Okay.
Apple installs this application on every single iPhone that it sells.
But if I understood your argument seemed broader than that. Are you saying that he has no interest in the government, no privacy interest in his movements, such that if the government, no matter what it does, however it finds a way to monitor them, that's fine with you? The government doesn't need to check with a judge before it starts doing that kind of searching?
No, Your Honor. My argument is not so broad. The Fourth Amendment scrupulously protects the sanctity of the home and other places where an individual would have a reasonable expectation
No,
of
I
privacy.
understand that, but if you're walking, his daily movements, all of his daily movements, is your position that the government, if it has a means of tracking that, can track it without checking with a judge first?
Yes, Your Honor.
No matter whether he has any idea it's happening, no matter whether the government gave him something that had, if the government had a way of doing it without giving him anything, the government could just go ahead on its own and start doing that tracking.
Your Honor, in a more constrained sense, yes. Police can track an individual along a public thoroughfare. They have no reason to shield their eyes as somebody walks by them on the street. This information that they received from his cellular records merely enhanced their ability to see him in public.
But it continued to
Further-
track him, let me interrupt you just a moment, it continued to track him regardless of where he was, including in his home. And you would agree that that is a constitutionally protected location.
Your Honor, it is not necessary for me to agree whether that is a constitutionally protected location. While the Fourth Amendment does scrupulously protect the home, even if police officers had wanted to see petitioner's movements within his home, it would have been impossible due to the imprecision of the triangulation technology. His home would have had to have been quite larger than a football field. In fact, to put it in perspective, his home would have had to be at least 3 football fields.
So are you saying you're saying then that there's no reasonable expectation of privacy literally just in the fact that you're somewhere in the home? The fact that you are at home as opposed to some other location?
Your Honor, the only thing that law enforcement could see was defendant perhaps arriving in the large vicinity of his home. They could not see his movements within the home. They may not have even been able to see him approach the door of his home.
Well, there seems to be some inherent tension in the use of this data because you're saying it's precise enough. It's being used to say it's precise enough to pinpoint him at the location of the post office, but it's so imprecise that we can't tell if he's home or not.
Your Honor, in this instance, there was probable cause for police officers to collect this data in the first place. There was an anonymous, excuse me.
No, go ahead, finish your answer.
There was an anonymous tip along with the clerk's statement that he had dropped his iPhone on the counter in the course of the robbery. Therefore, it was not necessary for police to pinpoint his exact location at the post office. However, this made it likely along with the other information that they received.
Suppose I had a concern about the idea that now that technology exists that would enable the government to track every movement a person takes, which you'd have to say when the Fourth Amendment was adopted was not a feasible possibility. Suppose I had a concern about suggesting that all that information was something that I had no privacy expectation in. Is there any way for the government to win?
Yes, Your Honor.
So how? That would be a narrower way of us deciding it. What would that be?
Your Honor, the third-party doctrine would apply in this instance. When Petitioner voluntarily was conveying his data to a third party, he reasonably should have known that that data could no longer be protected by his Fourth Amendment right.
So doesn't the whole notion of voluntariness encompass at least some knowledge?
Yes, Your
Necessarily
Honor.
some knowledge. So how do we assume, there's nothing in the record to say that he was even aware that his app was on his phone, let alone that it was tracking his every movement.
Your Honor, he had a social application installed upon his phone, which he could have disabled at any time and either failed to do so or decided not to do so.
Right. So the fact, though, that this app can be disabled or the triangulation services could be disabled is one thing. But don't you have to at least show, or shouldn't there be something in the record showing that he was even aware so he could know he needed to disable those services?
Your Honor, not necessarily. In the case of Caro versus United States, this court found that the defendant, on accepting the container of ether, which contained a beeper monitor device, the defendant accepted the container as it came to him, beeper monitor and all, and therefore he could not object to its presence.
Well, let me push back on that because the Caro case was not a third-party doctrine case. That was a reasonable expectation of privacy case. And the court also then went on to say that the original owner of that container had, in fact, given their affirmative consent. So that strikes me as a little bit different than this situation. Where's the voluntary act
Your Honor,
in this situation?
In this instance, I believe that the Caro case plays to the knowing portion of the third-party doctrine. Let me back up. The defendant should have known that.
wasn't the defendant getting messages from his cell phone that he was notified of historical events and locations that was being transmitted to him as a result of this app?
Precisely, Your Honor.
So would he know that he had something on there that was giving away his location?
Yes, Your Honor, that is precisely what I.
But aren't you asking for records that were obtained and created even in circumstances in which his phone would have been off?
Your Honor, no. I mean, in the point where his phone was off, that application.
Well, I had thought, under the record, even there were circumstances in which it could be giving the location information to AO, other than in times in which the person using the app would be notified that you're near something important. That it was all the time conveying that information, even when the app wasn't being utilized.
Your Honor, the record did state that the application worked in the background. However, the record was unclear about whether the application actually worked when that cell phone was off. However, it was clear that Petitioner could have disabled that.
But do we know the records you're seeking are exclusively records that were generated in circumstances in which the application was on?
Your Honor, the application does not track. The application does not track the petitioner's location unless it is enabled. And therefore, when the phone is on, yes, it is operating in the background. However, the record is unclear.
But I'm saying in those circumstances, we don't know from the record that every time the phone was on, he knew he was giving the information to AO, correct?
Correct.
Right, so as long as we don't know that, and you're seeking all of AO's records, some of the records you're seeking could be records he didn't know he was giving.
Your Honor, not necessarily in this.
Not necessarily, but possibly.
Your Honor, no. In this instance, Petitioner accepted the iPhone as it came to him, tracking it all. Therefore, he could not object to his presence.
Well, I understand that. That's just from getting the phone. But if we thought just getting the phone wasn't enough, in terms of what knowledge he had that while he had the phone, he was giving up personal information, from the record, there's nothing to indicate he would have known that he was giving up that information even when he wasn't utilizing the app, correct?
There's nothing in the record to suggest that. However, it would have been prudent for the petitioner to, at the time of the purchase of his iPhone, to read the terms and conditions. In the cases that have stood before this court, Carroll versus United States, Knotts versus United States, Smith versus Maryland, and Miller versus United States, well, perhaps not Miller, but the previous three cases, the defendant unquestionably did not know that his location was being tracked by police, or the data that he was giving up was being given to anybody else.
And that's a fair point. That's a fair fact in those cases. But the rationale of those cases was that he had not, or those defendants did not have a reasonable expectation of privacy in their public movements. That's a totally separate argument than what you're making here.
Your Honor, in those instances, in the instance of Smith versus Maryland, the third-party doctrine was upheld because they found that even if the defendant did not actually know, he should have known that by dialing the numbers on his phone, he was conveying that information.
So right, and so in that sense, you're accessing the phone app, or you're typing in a URL. You're consciously and affirmatively doing something. And the concern here is that this app is working in the background, even if the app isn't on or otherwise, being engaged with in any way.
Your Honor, even if the court does not accept that petitioner knew that he was being tracked at all times by this third party, he still did not manifest an actual and a subjective expectation of privacy in his actions by traveling along a public thoroughfare and carrying an app which he was conveying large amounts of data to multiple third parties. When he received notifications on his phone about historical sites within the area, or that his friends were walking about near him, he should have known that the phone was conveying that same information to his contacts who had the app enabled. And also,
I guess I'm wondering if you're assuming facts that we're not sure from in this record. I mean, the app had those settings available, but do we know that those settings were in fact enabled, such that he was receiving push texts?
Your Honor, he had the app enabled, or else police officers would not have been able to get this data. Therefore, we know that he must have been utilizing the app.
I thought even when the app was not being utilized, it was conveying information, according to the record.
Yes, sir, Your Honor.
So that means even in circumstances where he might not have known that he was conveying the information, he was.
Yes, Your Honor. If this court finds that he did not know and therefore the third-party doctrine would not apply here,
Well, before you concede that, what in our cases suggest that if a third party has records that it's generated itself, it created them for its own business purposes, that the records, by virtue of conveying information about someone else, trigger a Fourth Amendment interest of that other person? I don't know of a case where we've suggested that.
Your Honor, in Miller versus United States, the court found that upon conveyance of the individual's records to the bank, they were no longer his records to protect by his Fourth Amendment right. They were the bank's legitimate business records.
So is it your position that this is identical to that case then?
Your Honor, this is quite similar to that case because police officers, upon request, received the bank's business records that were no longer the defendants to protect. Here, when police requested this...
And I take it the defendant here, you would agree that if AO chose to tie up all these records in a pretty little package and send it to the FBI, and the FBI opened it, it could use them.
Yes, Your Honor.
Right, and so how is this case in a way any different than that, since from AO's perspective, they've consented to the government getting the records. The AO has no problem with the records being in the possession of the government.
Your Honor, this case is similar to that of United States versus Miller, in which the court upheld that the third-party doctrine did apply because defendant had voluntarily conveyed his records to the bank. And in doing so, he had made his records the bank's records for their...
Well, you keep throwing in that word voluntary. But I'm asking you whether the government's position is that it doesn't matter if he voluntarily did it. It doesn't matter if he know how it got there. Is the government's view that so long as those records were created by a third party, owned by a third party, and are in the possession of a third party, doesn't matter what the records are about, the only party that has a Fourth Amendment interest is the party that possesses the records?
Your Honor, I see that I'm out of time. May I answer your question?
Yes.
It does not matter as long as that information was conveyed to a third party and the third party voluntarily gave that information to police officers. It was that third party's information to give, and therefore Mr. Smith would not have an expectation of privacy in the cellular company's records. For the foregoing reasons, I request that you affirm the decision of the 12th Circuit. Thank you.
Good afternoon, Madam Chief Justice, and may it please the court. In an off-cited passage by Judge Cardozo, he famously quipped, "The criminal should not go free because the constable has blundered." The government does not contest the fact that the police blundered in this case. They executed a warrant on the 9th day when the judge had set out that it should be executed on the 7th day.
Are you agreeing that that voids the warrant?
No, Your Honor. The government's position is not that the warrant is void, because the probable cause that underlied the warrant was still valid, and in fact, by its very nature, unchanging.
How do we know that from the record?
The record only gives us that the probable cause was secured by an anonymous tip. That anonymous tip gave the name of the petitioner, Winston Smith. Now, this court's precedent in Illinois v. Gates dictates that an anonymous tip must be evaluated under a totality of the circumstances standard, and that an anonymous tip alone can be sufficient for probable cause. So we have to assume that the judge at the district court level went through this analysis and determined that the veracity of the anonymous tip made it so that it was enough for probable cause all on its own.
And there doesn't seem to be any challenge to the sufficiency of probable cause as sufficing to establish the warrant here. The question here, though, is that when it was executed, it was expired on its face, was it not? Why is that not facially invalid?
Your Honor, it is not facially invalid because the only police misconduct we're dealing here, which the exclusionary rule is solely intended to deter, which is police misconduct. The only misconduct is that they executed the warrant 2 days later.
Yeah, why is that not misconduct? I mean, why is that not a deliberate disregard of the date right on the face of the warrant?
This court has never specifically addressed the timeliness of a warrant as its own discrete issue. The case of Scroll v. United States is not applicable in this case because in that instance, they were evaluating a prohibition area statute that had to do with the timeliness of a warrant and specifically laid out that the warrant is to be executed in 10 days or it is void. This court has never addressed the Fourth Amendment backing behind the timeliness of a warrant. So for that analysis, we can look to 3 different circuit courts for their reasoning. And as Justice Kelly already mentioned earlier, United States v. Sims in the 10th Circuit laid out a 3-part test to determine if the timeliness of a warrant rises to the level of a constitutional violation. And in that case, they looked at the effect on the probable cause, the intentions of the police officers, and the guidance delivered by the Federal Rule of Criminal Procedure 41.
And who has the burden at that stage of the analysis? Because we know there's a violation, right? You're conceding the government acted unlawfully, and now you're just trying to say the evidence shouldn't be suppressed.
Yes, Your Honor.
Right. So given that the government has already acted unlawfully, why doesn't the government have the burden of proving that the unlawful action they took is excusable for some reason? And if the government has the burden, then why, when we have a record that doesn't say why the government violated it, what interest the government had for acting slowly, what the significance of the time constraint was, you want us to construe all those silences in your favor, and I don't quite understand why we would do that when the government is the wrongdoer.
The government may be the purported wrongdoer in this case, Your Honor, but the burden on the proof of proving the applicability of the exclusionary rule is on the petitioner. Now, in this case, the warrant was executed 2 days late. And to look for guidance, we can look at the Federal Rule of Civil Procedure 41, which courts have done in United States v. Sims and other circuit cases as well. And that limit is at either 10 or 14 days, depending on the version. The warrant in this case was executed on the 9th day, within the safe harbor set by that maximum time limit. However, more importantly is the fact that...
But I understand the government, no, I understand the defendant has the burden of proof, of trying to prove that it should be excluded. But what I'm asking is, when we have silence as to whether what the government did was malicious or excusable, you would have better access to information than the defendant would on that point.
Yes, Your Honor.
But you haven't given us any reason to think that it was excusable. So why should we assume that it was? How would the defendant know whether you had a good reason or a bad reason for violating the warrant? But if you don't even offer a good reason, why should we make one up for you?
The government in this case is not invoking the good faith exception.
No, I understand, but you're trying to say that it wasn't malicious. It wasn't an intentional violation of the warrant. It was just inadvertent.
Yes, Your Honor.
But we don't have testimony from the officer saying, oh, I thought it was still 7 days, I think weeks or 10 days, who knows why. But they didn't say anything like that, right? We just have silence. And in the face of that silence, you want us to just assume the best of the officer, even though it's the officers who would know why they made the mistake.
Your Honor, that kind of a fact-finding expedition is appropriate at the district court level.
And it wasn't done. But you could have made a record that would have been helpful to you. So since the government didn't, why should the government get the benefit of not having made that record? How would the defendant be able to make that record?
Because there's no prejudicial effect on the petitioner whatsoever, Your Honor. Even if we concede that it was intentional, which is nowhere in the record, the fact that it had no effect on probable cause and no effect on the defendant or the availability of evidence to the police in general necessitates that no prejudice means no exclusion. And every circuit court that has reviewed timeliness of a warrant as a discrete issue has held that probable cause is sometimes the sole analysis that needs to be taken. And that's the course that the Third Circuit took in United States v. Bedford. They said not reasonableness, not a mechanical counting of days. The probable cause is what's important here, because the probable cause is in the Fourth Amendment. It ties warrants to the Fourth Amendment. There is no timeliness of warrants in the Constitution whatsoever.
So why should we assume, though, that the probable cause is sustained beyond the 7-day limit here?
Because the nature of the probable cause itself dictates that it is unchanging.
Nature in what sense?
We have an anonymous tip that gave a name, the name of the petitioner. That name led police, in addition to the testimony that he owned an iPhone, led police to these data records. There was nothing about the petitioner's name that could change in 2 days, nor was there anything about the facts that the judge must have weighed to determine the anonymous tip was sufficient for probable cause that fundamentally could not change in 2 days. And more importantly, the information that had already been collected by AO was all in the past. These incidents happened in the past. All of his movements had been previously tracked and could not be changed. Nothing about the information that went into the warrant's issuance could possibly change in 2 days.
On this issue, is it significant that there has been no clear answer to this question up until what we're being asked to do today?
Yes, Your Honor. It is significant that I cannot stand here and cite Supreme Court precedent that makes my case for me. However, I believe this is the perfect opportunity for this court to finally lay down a reasonable test for evaluating the timeliness of a warrant, as plenty of circuit courts have done. The 11th Circuit in the United States v. Gerber, 10th Circuit in the United States v. Sims. It always comes down to a probable cause reasonableness analysis. And if we run that same analysis here, there was no effect on the probable cause, and it was perfectly reasonable for the police to rely on the existence of that probable cause when they executed the warrant. And more importantly, the police cannot be properly charged with the knowledge that they were violating the Fourth Amendment. You could maybe properly charge that they knew they were violating the time limit on the warrant. However, due to the fact that both the District Court and the 12th Circuit found that the police did not violate the Fourth Amendment, it cannot be argued that they could have been on notice that they were violating the Fourth Amendment if two courts have already
Did those other cases, though, involve situations where it was apparent on the face of the warrant that it was actually expired, as opposed to a warrant that later is found insufficient in terms of probable cause, or there's some other reason for police not to know at the time of execution that there was a problem?
Your Honor, I'm not sure about that. We don't even have the facts here, whether or not the police knew that there was a facially deficient date on the warrant when they executed it.
How could they not have known that? Did they not read the warrant?
I don't remember the case name in front of me, but I did come across a case where the date was so badly scribbled on the warrant that the police had no idea what it said.
And you want us to assume that this is that kind of case?
I do not, Your Honor.
Okay, so I think it's on the face of it, we can assume it was pretty clear.
Yes, Your Honor. However, like I said, this is a Fourth Amendment case. This is a case determining the constitutionality of the police's actions. It is not a case about respect for the judiciary and what they write on a warrant, or whatever reason they may have had for picking 7 days, because it certainly wasn't about the probable cause determination, because nothing was going to change in 2 days.
Right. Is this a good faith defense point you're making, or is this why we shouldn't suppress it?
The government does not contend that there's a good faith exception here, Your Honor, because there was no bad faith shown by Petitioner. There's no bad conduct that the government is attempting to explain away by showing either the police were relying on.
Well, whose burden is it to show reckless, deliberate action on behalf of the officers?
It is the petitioner's burden, Your Honor.
All right, so why are you giving up the good faith exception?
Because there's nothing to try to explain away here, Your Honor. The warrant was 2 days late. That's
Yeah.
all we know.
And you're not trying to say with it, well, big deal, it's only 2 days late?
I am saying that, Your Honor, yes. I see no big deal here. There's
All right.
no effect on the probable cause, no prejudice to the defendant.
You just
no-
say you just don't want us to rely on the good faith exception. You'd rather us rely on the fact that it doesn't justify the exclusion, because the factors that we would go into in weighing whether the violation was such that exclusion was necessary. But you're kind of muddying that, because you're also saying there's no Fourth Amendment violation. If there's no is there a Fourth Amendment violation here? There's a time limit violation.
Your Honor, I agree with my co-counselor, Ms. Shriver, that there was no Fourth
Well, I
Amendment
understand
violation.
that. No, but assume we don't agree with that. So he has a privacy interest. Does the fact that the warrant expired mean that the execution of the warrant was invalid under the Fourth Amendment?
No, Your Honor. Language in the Fourth Amendment has to do with unreasonable searches and seizures, protection of your home, your body, your effects, probable cause securing warrants. It has nothing to do with the time limit on a warrant.
But I thought the general, how can you say you're complying with a warrant when the warrant tells you you got to do X? How are you acting pursuant to a warrant?
Because the nature of the warrant is about the particularity of what's to be seized and the reasoning why that is valid under the law. As you've already mentioned earlier, the date that's put on a warrant could be done for any variety of reasons. It could be judicial efficiency. It could be the judge saying, hey, you only need 7 days to get this evidence. I'm not going to give you more time than that. We don't know the reasoning there. We only know that warrants are to protect the underlying probable cause determination. The time on a warrant, the fundamental nature of that is to protect that probable cause determination at the time.
Can I just ask you, suppose you guys executed this 10 years later? Fine?
No, Your Honor.
Why?
Without getting
Sounds like everything you said suggests it would be fine, because we don't care about the time
We don't care
limit.
about the time.
It's historic data, it's there, same guy, and you're just lazy, we'll wait.
The government would be perfectly happy to accept the Sims analysis and use the federal rules of criminal procedure as guidance here, as a maximum time limit. However, no matter what version of that statute you look at, that maximum time limit was not reached. And therefore, even if you wanted to use some sort of overall timeliness rule, we would still be within that safe harbor, Your Honor.
That seems like I just want to make sure I understand your argument. Are you basically saying these 2 days don't count because they still fall within the safe harbor of the federal rule? Or something more broadly about the irrelevance of any time limit in a warrant?
I would argue for a more expansive view where we're only looking at the probable cause. I would go with the Third Circuit in Bedford and say we're not looking at reasonableness, we're not looking at a mechanical counting of days, we're looking at the probable cause.
But you see, you're just sort of taking away the whole idea of a neutral magistrate. The idea of the neutral magistrate, I thought, was somebody other than you gets to decide when you can do a search. And so you went to somebody who's neutral, and they said, well, you can do the search with these parameters. And now the government says, yeah, he didn't mean that. Those are nice. But why would that make sense? The whole idea of having the magistrates, they set the rules.
Yes, sir.
And if you follow those rules, you're acting pursuant to the warrant, and then it's fine. And if you're not acting pursuant to the warrant, then you have a potential problem. You might be able to excuse it by saying there's no need to apply the exclusionary rule, et cetera. But you seem to be arguing you can just act outside the scope of the warrant, and it's not a Fourth Amendment violation. We should treat it as if you got a warrant authorizing you to do what you did, but you didn't.
That is not quite my argument, Your Honor. What I'm arguing is that, similar to United States v. Leon, when the police could reasonably rely on the determination of the magistrate, even though the probable cause was later found to be deficient, in this case, they could reasonably rely on the probable cause itself, which is even stronger than the determination itself. So therefore, because they could rely on that probable cause, the 2 days late was a de minimis error, and no prejudice has been shown by the petitioner at any point. And what we are concerned with here is the Fourth Amendment, is probable cause, is prejudice, is the effect on the evidence itself, not a date, not 2 days, not some decision that doesn't have a constitutional basis on its own. And because what we're dealing with is one piece of probable cause that gave a name that led to records, there's just no prejudice in this case, Your Honor. And on top of that, even if there was prejudice, the costs of excluding this evidence are simply too high, not only in this case where a conviction would have to be vacated from a dangerous robber, but also generally where a holding against the government in this case sets forth a per se rule that any late warrant automatically merits exclusion of evidence. Now, there is 1,000 different ways that the police could execute a warrant 1 minute, 1 day late with no bad intentions, with no ill
And
effect.
all they would have to do is put evidence in the record that they had no bad intention, but you didn't do that.
Right.
It is not for the government to prove the absence of good faith, Your Honor. It is for the petitioner to prove bad faith, or even a shred of bad faith, or even a speculative effect on their case, and they have not done so.
You're saying it's not the government's burden to prove a good faith exception?
If we're not trying to explain away specific bad conduct, if all we have is the warrant is late and nothing else, then we should look to the probable cause. And I will conclude by, again, asking that this court respectfully uphold the decision of the 12th Circuit. Thank you.
Thank you. Rebuttal?
Madam Chief Justice, and may it please the court. Both myself and Mr. Hennessy each have 1 point to make on rebuttal. Your Honors, what the government contended earlier was, I quote, "It doesn't matter if it is conveyed to a third party. It doesn't matter if it was voluntarily or knowingly conveyed to a third party." The government contends that this court is similar to what happened in United States v. Miller in 1976, when an individual voluntarily and knowingly wrote his bank information on a deposit slip that he handed over to a bank clerk that the government later used against him in court. Now, there was some issue about the record earlier that was mentioned during the respondent's argument, and the record on page 4 says, and I quote, "The app would serendipitously track users' locations regardless of whether the app was open on the phone." Your Honors, there's no evidence in the record in this case that Mr. Smith knew that he was transferring such information to a third party.
There's no evidence that he didn't know either. And whose burden is that?
Your Honors,
When you buy a cell phone, you know that you can get from point A to point B by using this app, or you can find a store nearby. Why didn't everybody know that? Everybody knows it.
Your Honors, and that, Justice Kelly, that is exactly why Justice Sotomayor, in her concurrence in United States v. Jones,
Just
said
remember, that was a concurrence.
correct, but it has been well cited that the third-party doctrine is ill-suited to be applicable in today's technological era, where people are conveying their information to third parties simply by carrying out mundane tasks. Therefore, we ask that this...
How different is that than Miller? I mean, most people like to use a bank. Doesn't
Yes.
seem that optional.
But
And
Your
yet,
Hon-
it was even stronger in Miller because the government had required the bank to make copies of the records.
Yes, Your Honor, I see my time is up. Would you mind if I
Please
answer?
respond.
Your Honors, the petitioner still contends that this case is distinguishable from United States v. Miller, where a person voluntarily and knowingly conveys his information on a deposit slip. Therefore, we ask that this court reverse the 12th Circuit's decision and find that a Fourth Amendment search occurred. Thank you, Your Honors.
May it please the court. The government speaks of the social costs associated with the exclusionary rule. We agree that this should be a concern for the court. Sitting before you today is a generation of Americans who have little control over where their private information is stored. Location data, intimate photos, personal conversations that we had in middle school are scattered across this country on various third-party servers.
And let's talk about the continuation of probable cause here. Can you respond to your opponent's argument that there's no reason to think that the probable cause tied to a specific name somehow dissipated after day 7?
Your Honor, there's no evidence in the record to reach a conclusion about probable cause. There is evidence in the record to conclude that the government violated a valid judicial determination.
Can you come up with any plausible account in which probable cause would have dissipated? I understand the point that the record doesn't tell us. I'm just curious whether you have any account that occurs to you as to how an anonymous tip about a name, which wouldn't change, and records of where that named person went, which also by definition couldn't change, would somehow grow stale after the 9th day, but be fresh after 7 days.
Your Honor, the technological era poses a threat to any finding of probable cause. Information is consistently changing. If this court were to set forth precedent that affirms the circuit court's judgment, then what's next? Here, the magistrate made a valid judicial determination of probable cause. The government ignored this judicial determination.
What changed between the 7th day and the 9th day?
Because a valid judicial mandate.
What changed? What fact is there in this record that there was any change whatsoever?
There are no facts in this
All right,
record.
thank you.
But we contend, Your Honor, that this case is about safeguarding the judiciary's check on the executive and compelling respect for this institution and its inferior courts.
Well, couldn't you also do that by filing a civil suit against the officers for violating the warrant?
Your Honors, we can file a 1987 suit, but here we're dealing with a man's freedom, and his constitutional rights were violated.
What about the rights of the public?
As I mentioned earlier, the public is entitled to be secure in their persons against unreasonable search and seizure.
How about unreasonable robberies?
Your Honor, the court must weigh the scales. What is it more concerned with? Potentially suppressing the truth in one case?
But if you're right, then we have this pretty elaborate doctrine about when we exclude evidence and when we don't. And I thought one of the considerations is whether there's any harm that flows from the violation to the defendant. And you can't identify any harm that flows from it being late, correct?
Your Honor, I see my time has expired. May I
You may
respond and
respond.
briefly conclude? Harm is here because the executive violated a judicial mandate. If probable cause persisted, then the executive should have returned to the magistrate and asked for the court's guidance to determine whether probable cause existed. Because the government conducted a search and because that search was unlawful, we respectfully ask that the court reverse the circuit court's judgment, invoke the exclusionary rule, and vacate Mr. Smith's conviction. Thank you.
Thank you. The court thanks counsel for their excellent arguments. This case will stand submitted, and the court will be in a momentary recess.
All rise.
Oh, sorry.
All right, if I could have everybody's attention, if you'd all please be seated. In just a few moments, the judges will return, and they'll be announcing their decision for best oralist and winning side. But first, I'd just like everybody here, if we could thank the participants for their spirited arguments. And I say spirited because Dean Anaya in his welcome remarks said that we expected the bench to be spirited. I think withering would have been perhaps appropriate from out of the gate. I think you saw that this was a super hot bench where the judges had prepared for the arguments, were ready to exploit the lack of a record that was here on both sides and really rake the litigants over that. And traditionally in these moments before the judges return, we usually do open it up to the audience if they have any questions of the petitioner or respondent side about their preparation, about what it must have felt like to be, grilled by a Supreme Court justice and 2 circuit court judges. We would like to invite that. Does anybody have any questions? Yes.
I should answer that question because I got interrupted in my intro. You just gotta kind of keep track of time and just kind of know that there's points you gotta bring in, and that if you don't bring them in within your time frame, that you're probably gonna lose. So if you can keep track of time really well, that's usually how I manage to fill in points I know you're
And something, right. Right, something you couldn't see probably where you were, which was the timing devices here are, hopefully will help in giving you at least the 1-minute warning when it goes yellow and to stop when it goes red. But I think practice is probably how you get it down to where you sort of know your 13-minute time or 15-minute time. Any other questions? Yes, in the back.
You have a conversation with somebody, they're not necessarily asking you a question, but you can still respond in kind and try to pick up what they're getting at. Like, what is their point of contention? What are they griping with? What are they trying to get you to say? There's usually some sort of trigger in the statement or the question that lets you know where you should be going. But I would say that's the best. Just answer.
Usually I find when the judge is making a statement, the answer is no or I disagree. Because they're trying to challenge your reasoning, and they will often, when we're up there, they're sort of taking the government's side, and when they're up there, you saw it, they're taking our side, and they're just interrogating you kind of the same way that professors do.
Not always. Sometimes they ask some folks. You got to nail those. That's important. If you miss a softball, you're in trouble.
Other questions? Yes, Mr. Cheney.
My question is for the petitioners. I guess I was interested, a little later in the round, you mentioned Justice Sotomayor's concurrence in Jones, and I was wondering if you guys considered kind of relying on that more early on and basically being like, yes, under the current doctrine, we likely lose, but this doctrine really was developed in a different era, and we basically just need to kind of set aside and possibly overrule those decisions in line with kind of what Justice Sotomayor said in the Jones case.
Yeah, that was my plan. To go right after, but Justice Barron was very content on saying that these were business records, which I actually briefed the other issue in the early rounds, and that was one of my main arguments. So I needed to get him to get around the fact that these aren't just business records, that these are something that you don't knowingly give to a third party. And then if I had more time, I would have gone after the old cases, but I tried to do it on my rebuttal.
And Mr. Cheney, Jones was just a couple of years ago. I'm not sure I would say it was a different era, but because I do remember when it came out. So one thing I did want to say, it always gives me a little bit of, flashbacks here to when I've been at arguments before about how difficult this is. And so for the 1Ls in the audience here, this is one of the highest forms of legal reasoning, analysis on your feet, and argumentation. And I think it is why the Rothgerber Moot Court competition is the showcase that it is. And it really, all of these students volunteered to compete in this competition, and there were other students as well who went through the early rounds. But this is really how you sharpen your skills. This is how you hone those skills to be a lawyer. And this is, I think, one of the highest forms. So I hope everybody in this room aspires to leave the law school with these kinds of skills. And the experiential learning opportunities like competitions for moot court allow you to do that. Mock trial does as well, and transactional. And so to the point that this can be a little bit of an infomercial for that, I wanted to say that, I hope that everybody in this room takes away from this what a valuable learning experience this is and what you can do. And, would any of you like to sort of comment maybe on how it is that you think it helps sharpen your skills, whether it be your 3L year or your 2L years?
I mean, I think being able to just pull a case citation out of nowhere to answer a question is maybe the most important thing I've picked up from this, because you can say whatever you want that sounds very reasonable and logical to a judge. If you're not backing it up with cases, then it doesn't come off the same. So I think really having a good knowledge of the case law so that you hear those triggers in the questions that you can throw those cases out, it's been my biggest, I think, learning experience in our court.
Timbre?
To add to that, moot court is a really important experience because it forces you to kind of like juggle multiple things. I was taking a full class of this semester and also doing multiple things, and I still had to write my brief and still had to make this oral argument. And I think as a young associate, all of us will find that we are busy juggling multiple things, and this is a good preparation for that.
I really took away the writing aspect of moot court. What else will find out when you go to your second and third year that there's limited writing opportunities unless you seek out a writing class. So these moot court competitions give you a good opportunity to really hone your writing skills, and you get critiques from barristers' counsel, which is really valuable. And I highly recommend doing moot court after this.
Yeah, Ryan and I both started this competition arguing for the government, and we were making many of the same arguments that Josiah and Timbre made. It forces you to look at both sides of the coin, and I think that's a really strong asset for effective reasoning.
All right. Well, we will wait for the judges just for a few more moments. I did want to take the opportunity to thank Andy Ball for organizing Rothgerber. Andy won Best Oralist last year and got the consolation prize of organizing Rothgerber this year, which takes a tremendous amount of time, selecting the problem, helping do the moots, checking the briefs, and then organizing all of the details for this. And this is a student-run event in many ways. And so, I thank Andy for juggling all that he does in his last semester here and running this. And then also the moot court division as a whole for all that that they do to help prepare students, I think, to this moment. So for the 1Ls in the room, there will be in the fall a appellate advocacy competition called CAC, the Colorado Appellate Advocacy Competition. In the recent past, this last year, the year before, I think we had as many as 75 students competing. It is a prerequisite to do external competitions, and so we have external competitions going to everything from space law, advocacy competitions to the national moot court competition, which this year was in Boston. But in order to be able to represent CU in those competitions, you should participate in CAC. That's a prerequisite. So you can just see how much of the student body participates in moot court as hopefully a sign of how important it is for your law school career. And so I hope everybody thinks about that. After the judges give their best oralist and best team, we do invite everybody to come downstairs to the Rothgerber Reading Room at the library for the reception. If anybody doesn't know where that is, I think there will be signs. You will go up the stairs to the second floor through the main entrance into the library and then down the set of stairs so that you're on this level for the Rothgerber Reading Room, and there will be a reception there. All right. With that, thanks for everybody's attention. Just still sit still here. We should be with the judges in a moment.
You may be seated. So thank you all. I know this has been the culmination of many, many hours of incredibly hard work, lots of preparation, over and above your class schedule and load. So I commend all of you for the time and effort and dedication you have shown to this competition. We've had vigorous debate behind closed doors, but we have arrived at a unanimous decision. I'm going to give the announcement of the best team and the best oralist, and then we are going to provide just some very brief feedback, and I'll start with Judge Kelly. But I'll just cut to the chase. After vigorous debate, the court has unanimously concluded that the petitioner's team won the team award. So congratulations to the petitioner's team. And the court would also like to congratulate Josiah Beamish as the best oralist. So, Judge Kelly, why don't we start with you?
Sure. Well, I'd like to thank you all for having us here, and the arguments were very, very good. We hear arguments all the time, and you all matched up very favorably to the best arguments that we have in the real world. This is the real world. I would just make a couple of comments, and I don't mean this for any particular individual. But you were all very responsive. You listened to our questions. You didn't try to talk over us, which is a very common trait. Don't give up a point unless you're just absolutely forced to. If you don't know what the answer is, don't try to sneak around us. Just say, I'm sorry, I don't know that answer. And don't overstate your position. Don't overstate the record. Don't overstate what a case stands for. And those are just some general thoughts, but I thought everyone did a really marvelous job, and it's unfortunate we can't just say, well, everybody won.
Judge Barron.
Well, what Judge Kelly says is right, because we do see arguments. I haven't seen as many as he has, but in the few years that I've seen them, I can definitely agree with what Judge Kelly said, that this was first-rate presentation in terms of style and in the substance of it, too. Just a couple thoughts. One is just, these are the product of team efforts, and we evaluate you individually, but we're also evaluating as a team. One of the things that's just critical in your legal career going forward is your ability to work with another person in producing legal products. And if you don't get anything else out of participating in the competition, learning how to do that well is really just an absolutely critical skill above and beyond the presentation itself, because whoever argued, the other one was also mooting, I imagine, I hope. And it certainly seemed as if that must have been the case. Your partner in doing it, learning how to do that with each other, is just absolutely critical. Just the difficulty with giving advice on oral argument, I find it's a little bit like lots of law school propositions. There's always an opposite proposition that's probably equally true, too. And a tension is between being persuasive and pushing your point, but also being realistic about how the bench is reacting to points and when to move on to another point. And getting that balance right is probably the hardest thing, I think, for an advocate, because conceding can be fatal when you shouldn't. But as a judge once said, concession is also good for the soul. So how you figure out exactly, where to be on that matrix is not always obvious. And it's true also for figuring out which arguments to present at what time. Each of you divided up, but then you've got many arguments within the suppression issue and many arguments within the Fourth Amendment issue. Which ones do you want to really press among those various ones? That's a huge strategic choice. Doing it in your brief is one thing, choosing what to emphasize in argument is a different thing. But I thought you all did just an excellent job.
I would agree. And a couple of specific things that often we don't see in our court is the amount of respect and professionalism that you showed today. You're respectful of us, you were respectful of the clock, you showed great attention to body language, you didn't try to talk over us. All of that professionalism really showed. And I certainly appreciate that. You all had great knowledge of relevant law. You were able to talk in a very knowledgeable way about each of the cases you were using to rely on to support your points. I would agree, stand and fight. Don't back down on a point unless you absolutely have to. We're testing you, and often, certainly in our court, we are pushing you to establish a legal principle that goes beyond the facts of your case, right? A principle that's going to be applied in Colorado by all lower courts. So sometimes the questioning is to test the principle that you're urging the court to adopt so that we can understand the parameters of that and make sure you're not going to drive us over a cliff by applying that principle in a future case or cause mischief or unintended consequences. So that's something to always keep in mind. One specific point perhaps on rebuttal, I would probably try very hard to use your time to respond directly to points that have been raised on the other side. And so that was certainly the focus of my questioning. I wouldn't necessarily view it, unless you think there's nothing to respond to, I wouldn't necessarily view it as simply an opportunity to give a closing argument, but rather to take advantage of an opening. If there's something that was left unanswered or you felt was inadequately responded to, take advantage of that rebuttal time for that purpose. That sort of concludes my remarks. Everybody did a fantastic job. It was an honor to be here today. It was an honor to have you argue to us and to sit here with Judge Kelly and Judge Barron. And let's get to the party.
Everyone rise, please. We want to thank the judges for being here, and we'll see you at the reception.